You're driving home after dinner. Nothing unusual, just a normal night. Then you see it. Red and blue lights, flashing behind you. Your heart drops. That instant, sinking feeling. The officer walks up, flashlight in hand, and asks, "Do you know why I pulled you over?" Every single day, drivers make one costly mistake. They think honesty is their best defense. That mistake turns a warning into a ticket into an arrest. I've analyzed hundreds of traffic stop cases and body cam footage. I've identified the exact phrases that land people in legal trouble. In this video, I'll show you 5 things you must never say during a traffic stop in 2026. I'll give you the exact words to protect yourself, while staying respectful, while staying safe. This is educational content only. For specific legal guidance, consult a licensed attorney. Let's jump in. Mistake number 1. Yeah, I was speeding. The officer walks up to your window and asks, "Do you know why I pulled you over?" Your mind starts racing. You replay what just happened. Maybe you were 5 miles over the limit. Maybe you changed lanes without signaling. Maybe you rolled through that stop sign. You tell yourself, if I'm honest and upfront, maybe they'll appreciate it. Maybe they'll give me a warning instead of writing a ticket. So you say it. "Yeah, officer, I was going a little fast back there. Sorry about that." The moment those words leave your mouth, you just confess to a traffic violation on camera. Body cams record everything. That admission becomes video evidence. It can be played in court. Why people make this mistake? We're taught from childhood that honesty is the best policy. We believe admitting our faults shows good character. We think the officer will respect it. We think honesty earns lenience. But legal proceedings don't reward character. They reward hard evidence. And you just handed them your own admission of guilt. The legal reality. That admission can be quoted word for word in any court proceeding. Your statement becomes the prosecution's best evidence. The officer doesn't need radar proof anymore. Your confession can stand alone. That one admission can prevent getting the ticket reduced or dismissed entirely. The evidence problem. Body cams capture your exact words with crystal clear audio. The prosecutor plays that clip. Your tone doesn't matter. Insurance companies can access these records. That admission can justify rate increases for years. Officer psychology. Do you know why I pulled you over? That is a documented interrogation technique used nationwide. It's designed to sound casual. Officers count on your instinct to explain yourself. The correct move. Say calmly, "No, officer, I don't know." "Can you tell me?" Let me repeat. "No, officer, I don't know." One more time. "No, officer, I don't know." This phrase is not rude. It's the truth. You genuinely don't know with certainty why the officer pulled you over, why this works. It forces the officer to state the specific reason. That creates a record. It prevents admitting to anything you might not be guilty of. It keeps the burden of proof on the state. It protects you if the officer's stated reason changes later. If the officer pushes back, repeat, "I'd prefer to let you explain the reason for the stop, officer." Stay calm, stay polite, don't guess. Bottom line, never ever admit to any violation. "No, officer, I don't know," protects you completely. That protects you from confession evidence. But mistake number 2 hands officers probable cause for a more serious charge. Your Fifth Amendment protection against self-incrimination only works if you invoke it properly. Admitting to certain behaviors gives officers legal justification to escalate beyond a simple ticket. "I only had a couple drinks." The officer has already explained why you were stopped. Maybe a lane change without signaling. Maybe slightly over the speed limit. Normal traffic stuff. Then the officer leans in and asks a very different question. "Have you had anything to drink tonight?" Your mind races. You did have 2 beers with dinner about 3 hours ago. You feel completely fine. You believe you're well under the legal limit. You think, if I'm honest about the small amount, the officer will know I'm not hiding anything. And I'll look cooperative. So you say, "Yeah, I had a couple drinks with dinner, but I'm totally fine to drive. It was hours ago." Everything changes. The officer asks you to step out. Before you know it, you're performing field sobriety tests on the roadside. Even though you may be sober, you're now under a DWI investigation. Why people make this mistake? They think partial honesty shows credibility. They believe explaining context makes the admission safe. All wrong. The legal reality. The moment you admit consuming any alcohol, you've given probable cause for a DWI investigation. In the officer's report, your statement becomes, driver admitted to consuming alcohol prior to operating vehicle. That justifies what follows. Field tests, breathalyzer, arrest, DWI charge. The evidence problem. Body cams capture your admission. That statement can't be taken back. Even if you pass every test, that admission causes problems. Officers can claim impairment regardless of results. Insurance companies access arrest records, not just convictions. That can cost thousands in increased premiums. Officer psychology. Police are trained that any alcohol admission equals potential DWI. When you admit to drinking, it triggers specific protocol. The officer must investigate further to protect from liability. They're looking for any sign of impairment to justify their case. The correct move. Invoke your Fifth Amendment right. Say calmly, I invoke my right to remain silent. I won't answer questions without my attorney. Repeat. I invoke my right to remain silent. One more time. I invoke my right to remain silent. This is not rude. This is not suspicious. This is your constitutional right affirmed by the Supreme Court in Salinas versus Texas. The court ruled you must explicitly invoke your Fifth Amendment right. You can't just stay silent. You have to say the words. Why this works? It prevents any admission being used against you. It signals you understand your rights. It creates a clear record of proper invocation. It forces the officer to rely on objective evidence. If the officer pushes back, repeat, I'm invoking my right to remain silent. And I'd like my attorney. Don't explain. Don't justify. Bottom line, never answer questions about drinking. Invoke your Fifth Amendment right immediately. Your Fifth Amendment stops verbal admissions, but your Fourth Amendment protects against unreasonable searches. Rodriguez versus United States established limits on detention and vehicle searches. Mistake number 3 bypasses those protections. You hand over evidence voluntarily that would otherwise remain protected. Go ahead and search. The officer has asked you several questions. You've properly declined to answer most of them. You've been respectful but firm. The officer seems slightly frustrated. Then they say, you don't mind if I take a quick look in your vehicle, do you? Just want to make sure everything's okay. That phrasing is deliberate. It's designed to sound casual and routine. Here's what goes through your mind. I don't have anything illegal. If I refuse, I'll look guilty. If I just let them look, they won't find anything. And I can leave faster. So you say, yeah, sure. Go ahead. The officer immediately begins searching. They open everything. 20 minutes later, your car's contents are spread across the roadside. Maybe they find something you didn't know about. Maybe nothing. But now your car is destroyed inside. Why people make this mistake? They believe having nothing to hide means no reason to refuse. They think refusing makes them look guilty. They don't understand consenting waives, Fourth Amendment protections, the legal reality. The moment you consent, consent cures almost any legal defect. Once you say yes, everything they find becomes admissible evidence. In Schneckloth versus Bamonte, the court ruled consent validates a search that would otherwise be illegal. The evidence problem. If the officer finds anything during a consent search, you cannot challenge it later. Body cams show you agreeing. The judge rules against you because you volunteered away your protection. Officer psychology. When officers ask to search, they don't have probable cause. If they had probable cause, they just search. The fact they're asking means they need permission. They're trained to phrase it casually. Officers interpret any response except a clear no as consent, the correct move. Say firmly but politely, I do not consent to any searches. Repeat, I do not consent to any searches. One more time, I do not consent to any searches. These 7 words protect your Fourth Amendment rights completely. Why this works? It preserves all Fourth Amendment protections. It prevents searching without probable cause. It creates a clear record you didn't consent. If they search anyway, your attorney can challenge it. If the officer says, if you've got nothing to hide, why won't you let me look? Respond, I'm exercising my Fourth Amendment right. I do not consent to any searches. If they threaten to call K9, respond, I understand, but I do not consent. Am I free to leave? Under Rodriguez, officers cannot prolong stops beyond necessary time to bring drug dogs. By asking, "Am I free to leave?" you establish they're holding you beyond scope. Bottom line, never consent. "I do not consent to any searches" protects you. Absolutely, that protects from searches. But 2026 brought new distracted driving laws. 43 states updated electronic device usage statutes with stricter penalties. Mistake number 4 hands them a conviction. "I was just texting for a second." The officer says, "Were you using your phone?" "You were checking a text at a red light." You think explaining it was brief makes it okay. So you say, "Yeah, I was just checking a text real quick." You've confessed to distracted driving. Under 2026 statutes, any handheld phone use while operating a vehicle is illegal. Doesn't matter if you were stopped at a red light. The law defines it as using a device while controlling the vehicle. Why people make this mistake? They think context makes behavior less serious. They don't realize the law doesn't care about duration. Any admission of use is a confession to violation. The legal reality. In 38 states, distracted driving violations now carry mandatory license points for first offenses. Points trigger automatic insurance increases of 20 to 40% for 3 years. Fines increased from $50 to $100 to $150 to $300 for first offense, up to $500 for subsequent. These are now used as negligence evidence in civil cases. The evidence problem: body cams record your admission. The officer doesn't need to prove they saw you. Your confession is sufficient. These violations are categorized as moving violations. They hit your record more seriously. Officer psychology. Police are specifically trained in 2026 to ask about phone use, because most people admit to it. Officers are told, if you suspect phone use but didn't clearly see it, ask directly. Most will admit it. The correct move: say calmly, "I prefer not to answer questions. I invoke my Fifth Amendment." Repeat, "I prefer not to answer questions." Again, "I prefer not to answer questions." Why this works? It prevents confessing. It forces the officer to rely on what they observed. If they didn't clearly see you, they may lack evidence. It preserves your ability to contest the ticket. If the officer says, "I saw you looking down." "What were you looking at?" Repeat, "I'm exercising my right not to answer questions, officer." Bottom line, never admit to any electronic device use. Invoke your Fifth Amendment right immediately. Now you've protected yourself from specific violations. But there's one more category that's subtle and dangerous. People think they're being conversational, but every word is documented for investigation. Under Terry versus Ohio, officers use any statements to develop reasonable suspicion. Mistake number 5 is most common because it seems harmless. "Where am I going?" Or, "Just heading home." The officer asks in a friendly tone, "Where are you headed tonight?" Sounds like small talk. You think, what harm could it do? So you say, "Just heading home from a friend's house." You've given investigative information, your travel pattern, your timeline of activities, reasons to ask follow-up questions, a baseline statement to compare to other information. Why people make this mistake? The question sounds conversational. The officer's tone is casual. People think being polite requires answering. They don't realize there's no casual conversation during traffic stops. The legal reality: these questions serve investigative purposes. If you say you're coming from downtown bars, the officer has reason to ask about alcohol. Every answer opens the door to more questions, more detention, more opportunities to investigate. The evidence problem: answers get documented in reports. If the area is known for crime, that justifies investigation. If you later say something inconsistent, that suggests deception. Body cams capture everything. Officer psychology. Police are trained to keep people talking. These casual questions serve multiple purposes. They keep you engaged so you don't invoke rights. They gather information justifying extending the stop. They establish a conversational tone that makes you answer harder questions. The correct move: say politely, "I prefer not to discuss my travel plans." "Am I free to leave?" Repeat, "I prefer not to discuss my travel plans." One more time, "I prefer not to discuss my travel plans." Why this works? It prevents giving information used for investigation. It signals you're aware this isn't casual conversation. It keeps the interaction focused on the original stop purpose. If the officer says, "Why won't you just answer?" Respond, "I prefer not to answer questions about my activities. Am I being detained or am I free to go?" Officers can use statements as reasonable suspicion to justify further investigation. Under Terry, they need reasonable suspicion to detain you beyond time necessary to complete stop purpose. Your answers provide that suspicion. Bottom line, don't discuss activities, destination, or origin. "I prefer not to discuss my travel plans" protects you. Let me give you the 4 core phrases protecting you in any traffic stop. Memorize these. Number 1, "Am I free to leave?" establishes whether you're detained and how long. Number 2, "I invoke my right to remain silent," or "I plead the fifth," protects from self-incrimination. Number 3, "I want to speak with my attorney," ends interrogation. Number 4, "I do not consent to any searches," protects Fourth Amendment rights. These 4 phrases cover every situation. Memorize them, practice them, use them. Core principle: cooperation does not mean conversation. You cooperate by providing license, registration, insurance. You cooperate by following lawful orders. But answering questions is not cooperation, it's self-incrimination. Take out your phone now. Create a note with these 4 phrases. Print a copy for your glove box. Practice saying them out loud. When you're pulled over, these phrases should come automatically. Remember, this is educational content only, not legal advice. Always consult with a qualified attorney in your state. If you found this valuable, click like. Subscribe for more legal education on traffic stops. Hit the bell so you never miss updates that could protect your rights. Share this with friends and family. Everyone who drives needs to know these protections. You just learned to avoid the 5 most costly mistakes during traffic stops. But there are other aspects of traffic stop law most people don't understand. I break down complete legal frameworks for those encounters in the next video showing on screen. Watch it to complete your legal education. Stay informed, stay protected. Remember, the smartest thing you can say during a traffic stop is as little as possible. Your rights only work when you use